Defense of property is actually fun to teach because it also, again, relates to our conversation is what is really trying to accomplish. Is it a moral judgment or is it economic judgment? Sometimes we're in week 3 or 4, and students they get a feel for, okay, well, it's wrong to enter somebody else's property, it's wrong to do things, and so you should be able to, defend and repel such attacks. And the question becomes, well, how much? Right? And so I teach a couple of cases involving spring guns, where basically a property owner sets up a gun that's tied to a spring, and a trespasser, or usually a robber, trips the spring when they're engaged in their own nefarious activities and get injured or killed or whatnot. And I teach 2 cases, one from 1800s and one from actually late 20th century, very similar cases. The reason I teach both is because the older case involves an innocent party. Funny, it's actually 2 businessmen side by side. One raises tulips, which at the time was there's a rage for tulips. Everybody wanted tulips and they were super expensive. The other one apparently raises peacocks on a neighboring plot of land. So these are people catering to some very wealthy members of society. And unfortunately, one of the peacocks gets away and goes to the neighboring plot of land. The peacock owner thinks oh my God, he's gonna cause so much damage. Tulips are insanely expensive. Well, I'm gonna go and gonna retrieve the peacock as quickly as I can before I'm on the hook for all sorts of damages. And he goes there and he sets off the spring gun, which was installed because the tulip owner actually had been robbed previously and he wanted to make sure that doesn't happen again, or if it does, the people will pay the price. And so the court says that this is inappropriate way to defend one's property. Here's basically a good guy who is trying to protect his neighbor's property from his errant peacock. It sounds terrible that he was so grievously injured by a gun. Whereas the 20th century case is basically, again, same setup, there's a spring gun, etc. But the person who gets caught, he's a thief. He keeps breaking into this barn and he steals some sort of bottles. And he basically testifies in court. He's yeah, I did it twice before and I would do it again. And he's I don't really intend to stop. And so the property owners are well, but if this is the way to stop you, right? And the court there says, no, even if you're trying to catch a bottle thief, you still don't get to kill a person or grievously maim him to protect your bottles. It's not so much about are you a good guy or a bad guy, is that there's standards, how law will allow you to defend your land and how it would not. And then there's a third case I teach where there's not a spring gun, there's an actual gun being discharged, and there's some sort of mini riot going on in the Wild West, this is 40s, 1850s, I believe in Nevada. All this happening in front of our defendant's home. There's his shop on the first floor, there's his house on the second floor, his sister is sleeping in the house, and there's this mob gathering around. The sheriff and deputies show up, but the homeowner doesn't recognize the sheriff, and so he discharges the gun into the crowd and injures the sheriff. And the court there says, now you're no longer defending just property, you're defending yourself and your sister. If that's reasonable force, the fact that an innocent party, i.e. the sheriff who actually came to solve the problem, got injured, it's unfortunate, but not compensable because the person was using reasonable amount of force. So we talk about defense of self, defense of others, and how the amount of force you can use depending on what exactly you're defending may change it.